Welcome to National Resource and Training Services Private Investigation Seminars. Today's course is Courtroom Testimony and Demeanor. Upon completion of this course, you will be given an exam. After completing the exam, the results will be reviewed with you and then transmitted back to National Resource and Training, where they will then be directed to the state agency responsible for your continuing education requirements. You will also see a link at the end of the exam, which you may click to save or print a copy of this course for your personal use. Thank you for attending NRTS Online. Today's course will be presented in 3 sections. First, we'll talk about preparing for trial. Then we'll talk about what to do and what not to do in the courtroom. And we'll end up with some legal issues and ethics. To be successful in the private investigation business, you need to be able to present your case effectively and professionally in a courtroom. Whether in front of a judge or judge and jury, preparation is the key. The following can help you in this pursuit. Training, such as you're receiving today. You can never get too much training. Talk to private investigators or other law enforcement persons with court experience. There's a lot of people out there in our business that have had plenty of court experience and would be glad to speak with you about that. Sit in on some court cases and observe. Most times the public can sit in on court cases. Your best shot at this would be to attend some sessions court cases. Talk to attorneys that you know or work with. Talk to persons you know who work at your local courthouse. Every judge is different. Get as much information as possible. If you have a case in your local county and you know the judge is there, then use the information that you have. If you're going into another county or an unknown court, then speak to the attorney that's handling the case, or speak to someone in that county in law enforcement and get as much information as you can about the judge. What is the judge like? Is the judge firm? Is the judge fair? Is the judge grumpy? Find out what his likes and dislikes are as far as what goes on inside his or her courtroom. Keep up with technology. What's being used locally? If you're presenting evidence in court, do you need to have it on video on VHS, or would DVD be okay? Does the court have the capability of playing back audio, or are you going to need to bring your own audio equipment? Find all these things out. Get as much information as you can. In preparing for court, here's some things you should know. Make sure you know your license number and the number of years that you have been a private investigator. Your training history. Have this information on a sheet of paper, or have it prepared and ready to hand to an attorney or anyone that might need the information. But have your training history written down. How does the equipment work? Your camera, your recorders. Make sure that you're able to explain how the equipment is used. Know the laws governing your occupation. Know the names of all people that were involved in the case. Have this information available. Do not carry a weapon to court. Learn the general courtroom rules. As we discussed earlier, you can find out what the general courtroom rules are by speaking with your attorney or someone that works in the court. And by all means, log your time. This is billable time to your client. When scheduling, make sure you keep track of all important court dates. Don't let yourself be caught off guard. Make sure that you're keeping close contact with your client and your client's attorney so that you're aware of important court dates and you've got those on your calendar. Maintain close contact with your client's attorney. Inform your client's attorney well in advance of any conflicts in scheduling, such as scheduled vacations, other court cases, and availability of your staff. Keep in mind that when all parties involved have sufficient notice, most cases can be continued to avoid conflict with your schedule. But this is not always going to be the case. So in some cases, you will just have to drop everything and be there. Remember, this is extremely important to your client and to your business. Provide your attorney with a thorough summary and a case report. Attorneys rarely like to thumb through 17 pages of reports, so you should always provide your attorney with a one-page summary summarizing the entire case, what evidence you have, what you did, and what you know. Go over all the evidence with the attorney, including your information sources, your video, and recordings. Make sure you have copies for yourself, especially in court. And there's nothing wrong with having a copy of your report with you on the stand if you need to refer to it or refer to your notes when you're testifying. Make sure all names, locations, dates, and times are correct. Go over these well before you go into court. Prepare an informational sheet about yourself, and it should contain your full name, age, current and past occupations, and any special training and education you have, such as the course you're taking today. Advise your client's attorney well in advance of any conflicts you may have with other parties. And once again, very important, log your time. If using video, know the preference of the court you will be in. Do they prefer VHS or DVD? A lot of courts now are capable of handling DVD, and this is nice for private investigators because DVDs are less bulky, less expensive, and are easily stored. If using audio only, are you going to take this on CD or cassette? Would a PowerPoint presentation or overheads be useful? And if so, does the court have the equipment to handle this, or would you need to bring it? Make sure you maintain copies of everything. Know the names and qualifications of any outside experts used in evidence preparation, especially when you're dealing with computer forensics. These people may be needed to testify in court. In other words, if anyone helped with the preparation of your evidence as a computer forensics person or a photographer, make sure that these people know that they may be needed to testify on behalf of your client. Be professional in your presentation, and never ever falsify any piece of evidence or report. When talking about equipment needs, find out what the court has available for you to use. A lot of courts will have everything that you need, but if not, make sure that you have the equipment to use, and also bill your attorney and your client for the use of your equipment. Have on hand a small TV with VCR combo, a portable DVD player, some type of audio player to play your audio tapes or your audio CDs that you may use for evidence. But be prepared for any situation. And also keep in mind to bill your client for any special items needed. Let's discuss about what to do in the courtroom. First of all, let's talk about proper attire. What you wear should not be what is remembered. If the way you were dressed or presented yourself is what's being discussed hours after the trial, or that's not what you want. So dress conservative. Avoid excessive jewelry. Avoid religious and political symbols. You don't want to go in there with a large elephant designating your political preference on your lapel. This may turn someone off that's on the jury. It may be irritating. It may distract people away from things that you're trying to say that are more important. So just avoid it. Dress to the local standards. Find out what everyone dresses like in a particular court. Most times for guys it's going to be shirt, tie, and dress slacks. You may want to wear a suit jacket. Just find out from your attorney what the standard is for the court you're going to be going into, and then dress accordingly. General grooming like hair, nails, and shoes. Make sure your hair is combed, your nails are done, your shoes are shined. Ladies should be modest. And keep in mind, you can always dress down, so don't worry about overdressing. Continuing within the courtroom, turn off all pagers and cell phones. This is very distracting. No intimidating gestures or looks. No matter how personally involved you may get in this case, don't become emotional. Do not let your emotions show. Be professional. Be courteous in all your responses. You don't want to show anger. You don't want to show distaste. Just be polite to everyone involved. Show the proper respect to all parties. Keep in mind, the opposing attorney may be a future client of yours, and they are only doing their job. Everyone in that courtroom is doing their job, so don't let it be personal. Show confidence. Do not look intimidated. Look like you know exactly what you're doing. Even if you feel like you don't, show confidence. While on the stand, listen to the complete question before answering. Most of us want to open our mouth and start talking before we've actually heard the entire question and before we've had time to think about our response. So listen to the complete question before you answer. Then take a few seconds while you formulate your answer and then proceed. Wait for objections and the judge's ruling. A lot of times you may feel like when you're being asked a question that your attorney should object to this. Give him time before you start answering. And then when an objection is made, wait for the judge's ruling. Don't start talking before the judge has ruled. It's okay to ask for the question to be restated. Now, you may not have heard the question right, or you may have been confused about it, or you simply may not have your answer formulated yet and you just need a little bit more time. Rather than sitting there looking confused, just ask for the question to be restated. This is going to give you a little more time to think your answer through before you respond. Always look at the person asking the question. Then slowly turn to the judge or jury when you answer. If you're in front of a jury, look at the attorney or the person that's asking you the question, then turn toward the jury and respond to the jury. These are the people that you're answering to, not the attorney or anyone else. It also makes it personal with the jury. They can see your face, they can see your eyes when you're talking, and they can form a trust with you. Never offer more than was asked. Limit your answers to the facts. If you need to, ask permission to review your notes. There's nothing wrong with this at all. And always, without fail, tell the truth. When responding to hostile questioning, do not respond in anger. Usually this is what they're trying to do, is get you rattled, get you off your game, or draw attention away from more important things and throw up a smoke screen. So don't respond in anger. Be professional. Keep in mind, brief answers are always the best. Don't give a long, lengthy answer to a question that doesn't require anything more than a yes or no. If that's all that's required is yes or no, then give only a yes or no. And remember, don't take it personal. Remember, this is their job. Be courteous and be professional. Some traps you want to avoid: think before you answer. It's always better to take your time than it is to change your answer. You'll never look foolish when you're sitting there thinking before you reply. When you look foolish is when you reply and you think to yourself, oh no, that is not what I wanted to say. It's very hard to then say, I need to change my answer. You look unsure to the jury, and you look unsure to your client. Do not give opinions which are outside your expertise. Stick to what you know. State the facts only based on your work. Once again, avoid getting emotional. Remember, you're the professional here. You want to show confidence. You want to show professionalism. Don't get emotional. And be prepared. There is no reason, when you know well in advance that a court case is coming up, that you should not be prepared. Have your notes, have your reports, have your video, your audio. Be ready. Be prepared. Let's talk a little bit about legal issues and ethics. First, as far as the case file, advise your attorney of the items you have. There's no reason to surprise the attorney or the client with items they've not seen. It doesn't work like it does on TV, on Perry Mason. You don't want to surprise your attorney with anything. Make sure your videos are in usable format. Make sure these things are going to work. When you get in court is not the time to find out that the equipment's not working or the video's been erased or is unusable. Keep in mind, your notes can become court evidence. So don't write anything down or put anything in your reports or notes that you don't want seen in court. Make sure everything is date and time stamped. And remember to ask permission to look at or refer to your notes or reports. With your reports, make sure that they're professionally prepared and presented. Make sure these reports are on your letterhead. Remember, this is advertising. Make sure they're neat. Make sure they're factual. And once again, make them brief as possible. Make sure you cover all the important points, but don't go into such great detail that you've got 30 pages of reports when 5 would do. Only the important and pertinent information should be included. Make extra copies and have them on hand. When dealing with evidence, keep in mind that you need to know what is needed to present your evidence. Are you going to need to take special equipment to the courthouse, or do they already have this equipment? Just make sure you know what you're going to need to present the evidence you have, and don't overdo it. There's no need to make a big, huge presentation if you could simply use photos to pass around. And remember, photos are easier to pass around than video. Have important photos available to back up your video. Make sure copies are clearly stamped as copies. Never represent something as an original document if it's not. Be aware of any chain of custody issues. And if necessary, have chain of custody forms available for inspection. And remember, be prepared. Be factual. Never ever fabricate a piece of evidence or anything that you say in a court of law. It's called perjury, and you don't want to go there. Be courteous to all parties involved. Represent yourself and your profession well. Remember, when you're in court, you're advertising not only yourself but your business. Never overcharge a client, but make sure you bill for your time. A lot of investigators are a little bit shy about that, but you bill for your court time. You bill for the time that you spent preparing reports, preparing evidence. Never become hostile with any party involved in the case, no matter how mad you may get. Just don't do it. And never ever falsify or misrepresent. As you can see here, just the facts, ma'am, just the facts. You will now be given a brief exam. When you finish this examination, you can review your results, and like we said earlier, these results will be transmitted back to NRTS to be given to the state agency responsible for your continuing education. Also, there'll be a link you can click to print out a copy of this course for your personal use or to save on your computer. Thank you for attending NRTS Online.